All right, that's better. I'm going to talk to you about the fun stuff called elder law. Well, forget that. Okay, what we're going to talk a little bit about, though, is something a little bit more important. Elder law is such a terrible word. It really doesn't describe what I do. What is a better description of what I do is I help my clients protect and preserve their assets, their life savings from the costs of getting older and from the costs of drawing the wrong disease card. You see, as you get older, you run into the possibility of getting some diseases, and Parkinson's is somewhat age-related. It's obviously not directly connected to age, but I find that more of my older clients will have it than younger clients. When you run into this particular degenerative disease process, you run into some very particular legal issues that I want to give you a little heads up on today and talk about. The reason why I say unlucky enough to pull the wrong disease card is because there's an inequality, at least I believe, in the way we have our healthcare delivery system set up in this country. See, if you're lucky enough to have cancer and have to go to the hospital and you are over 65, your life savings will be preserved. All the treatment, all the chemotherapy, the radiation, the surgery, all of that will be taken care of under Medicare, and your financial resources more than likely will not be devastated by that particular disease process. However, if you're unlucky enough to pull the Parkinson's card, that particular disease process can wipe you out financially. And I wanted to give you a little heads up on that. Why? Well, you see, at some point in time in this journey, you may need the assistance of some home health care, maybe assisted living, or ultimately maybe even the nursing home. The cost of a nursing home in our community right now runs about $8,000 a month. So for all but the richest of us, that type of outlay on a monthly basis, that financial equation equals zero very quickly. That zero is your bank account. So my job for the last 22 years has been to help my clients qualify for public benefits to pay for the cost of that care. And the reason why I say there's an inequality is because Medicare is not going to pay for that long-term care treatment in a nursing home. The only government help that you can get, government assistance, like Medicare, in this case it's going to be called Medicaid. In order to qualify for Medicaid, you have to meet certain financial eligibility requirements. And one of the things that I do primarily, when I want to talk to you a little bit about today, is how to meet those financial requirements, what they are, and what you can do, and perhaps most importantly, when you should do it. Before we jump into that, though, I wanted to take a little care of a little housekeeping. We have a little booth out there somewhere. My assistant, Dale Davis, is here. She's been manning it this morning. There's a couple of things that I'd like you to pick up before you leave, not the least of which is a CD-ROM. On this particular subject of Medicaid and equalizing the playing field, I produced a CD-ROM for all of you guys. On here, there's a 2-hour presentation discussing public benefits in Medicaid. There's a 250-page book on Medicaid that I wrote. There's a video with Channel 13 when Kathy Fountain and I talked about the new changes in the law. So it's a 45-minute video that's on here as well. So there's a lot of great information for you that you can extend your learning experience from today at home. There's no way that I have, and the time that I have with you, that I can go into the detail that I would like. But with this, I can't. So please get one of these before you leave. Take it home. Has to go in your computer. Won't go in your CD player in your car. One thing I also want to talk to you on a housekeeping measure is a little bit, before we talk more about Medicaid and financial situations, I want to talk a little bit about incapacity. One of the things that I do in my practice is I deal with this issue of not being able to manage your own affairs. Now, all of us have seen somebody reach this point in their life, whether it was a relative or a friend or a neighbor, where mentally they cannot deal with their affairs any longer. They've lost the capacity to take care of themselves, take care of the things that they need to take care of, to be themselves. So when you run into that particular situation, you need to have some sort of plan in place which will hand over or at least duplicate your authority that you as a person have in somebody else so that they can step up and literally fill your shoes to manage the affairs that you would have normally been able to manage. Now, in this case, when we're dealing with Parkinson's disease, this journey again will start at one place, but eventually can lead to a position or a place where the individual does not have the cognitive abilities to manage their affairs any longer. So it's very, 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 that's 3 varies, very, very, very important that you have some sort of incapacity plan in place. And not just really any old incapacity plan in place, but one that specifically addresses several particular issues. So I have a little orange sheet that's out there on my table, and it's double-sided, and then there's 2 things that you need to take a look at. One side, it's called the Big 5. The Big 5. These are the 5 things that are most commonly missing in powers of attorney when I review them that are commonly not there. And if they are not in the document, then you or their backup person can't do these things. These are actually critical omissions that I see about 80% of the time. That means if everybody had a power of attorney in here today, 8 out of 10 of those powers of attorney would be wrong. 8 out of 10. And that's a pretty darn high percentage. Why are they wrong? Well, it has to do with the way the Florida legislature set up the power of attorney statute. When they set up the power of attorney statute, they put a sample power of attorney in the laws of Florida, and that sample was flawed. It was very conservative in its grant of authority and didn't go far enough in doing certain things that need to be done. So if you take a look at the 5 things, there are 5. One of them is the ability to create a trust. In order to be eligible for benefits, for Medicaid, for example, you may need to have a trust created in order to preserve your assets and reduce your income below the cap amount. We'll talk about you need this ability to create a trust. If that ability is not granted in your backup person, if it's not in the power of attorney document, that document needs to be redone and is fundamentally flawed. This is where close is not good enough. It has to have this very specific language. Second thing, the ability to make gifts, specifically unlimited gifts, including gifts to the person who's your backup. So let's say you've named your wife to be the backup person, and she's going to take over your affairs in the event that you can't manage them. Okay? Well, as part of the Medicaid planning process, as part of qualifying you for these benefits, I may want to make gifts. And maybe make gifts to her or make gifts to family members. Or I may want to change the title to the house, for example, and move it from both names and just put it in one name. If this authority to make gifts to the power of attorney themselves is not present, your wife cannot move the house just into her name. I may want to do that in order to clean things up to make sure everything flows correctly legally. I want to have it in her name only because she's the healthier spouse. But if you, the person giving her that authority, do not have the capacity any longer to sign, we cannot get there from here unless this power of attorney empowers your wife to sign on your behalf. So second thing, power to make gifts specifically to the power of attorney. Third thing, everybody ever heard of IRAs? Individual retirement accounts. May have one, right? IRAs are an asset, and when it comes time to qualifying for Medicaid benefits, you're going to probably need to manage that asset in some way. And even if you're not trying to qualify for these benefits, you still may need to manage it, change the beneficiary, make distributions, change the investments. If you don't have the mental capacity to do that any longer, your spouse or sister or brother or child doesn't have the authority to manage that on your behalf unless you've given them that authority in the document. And basically the document has to say they have the authority to manage my IRAs and other tax qualified plans. That language isn't in the document, it's no good and needs to be redone. Plain and simple. I've seen it time and time again where a client will come in with a flawed power of attorney. We need to access the IRA account to do something with it, and we can't do anything with it because when they show up at the bank, the power of attorney, the bank looks for this language, it's not there, and they say no. The big red stop sign comes out, and we can't manage that. And since we can't manage it, I can't move it, I can't reposition it, I can't recharacterize it, I can't fix it to protect it so that it won't keep us from being eligible for Medicaid any longer. So it's off to guardianship court. It's several months of going through guardianship unnecessary expense and time and money just to get the authority to tweak the IRA the way I need to tweak it to make it disappear. So bottom line is this third thing is the ability to manage tax qualified plans like IRAs. If that language is not in your document, it needs to be redone. In Florida, fourth thing, in Florida we have an interesting constitutional provision regarding your house. Your house is a super asset. It's got all kinds of protection because it's your house. And Florida's Constitution says, for example, when you die, that your house goes to your spouse or goes to your kids without any creditor claims sticking to it. They just get washed off. So if you owe, your credit card has been overdrawn and you owe $20,000 to Visa and you have a judgment against you from some bad business deal or whatever, if that judgment's sticking to the house, when you die, it gets washed off and your heirs receive that property free and clear of any creditor claims. And one of the biggest creditor claim is if you've gone through the nursing home and been on Medicaid, the state of Florida has a lien against your estate when you die. So you have to pay it back when you're dead. Well, the only asset that you have usually when you're on Medicaid will be your house. Can Medicaid take your house when you die? And the answer is no, because of Florida's Constitution, because of the super status as your homestead. Well, since it has this special status, the title insurance companies want to make sure that your backup person has the authority to convey that thing, has the ability to sign the deed. And if they don't have that authority, the title company says, no, we can't let you sign the deed, you can't convey the house. So fourth thing, the ability to convey the homestead. The fifth thing on my big five list regarding powers of attorney, the fifth problem that I commonly run into is the failure to appoint a backup to your backup. So I'm naming my wife to be my power of attorney. I want her to take care of my affairs if I can't manage them. I'm okay today, but I got this disease that could screw up with my brain enough that I'm not going to be okay in the future some point in time, so I want you, honey, to take care of my affairs. I lose my capacity to manage my affairs in the future. She's taking care of me, she's managing everything, and then she gets run over by a bus. Who's going to be there to fill her shoes that are filling my shoes? You need to have a backup to your backup so that that problem is resolved. And it's very common that I find that most power of attorneys only name one person, not a backup to the backup, naming two people. All right? Very good. Any questions on that particular area that I could answer for you? Yes, ma'am. I love that. Her question is, what about having two people on the power of attorney together in the beginning, right? Very common question, and I have an answer for you. There's a reason why they put only one steering wheel in a car. Do you understand my answer? Okay. Because the worst case scenarios I've ever run into is when I have a kind of together type of situation. Instead of being next to each other, I like to do this. One primary, one to fill those shoes if the primary person can't do it, but never both in the front seat at the same time. Okay? It's a good question. Any other questions on power of attorneys? Yes, ma'am, all the way in the back. Sure, it can be anybody you want that's over 18. Okay? And they don't have to live in Florida. They don't have to be related to you. It can be anybody that you want. But I will tell you that the document's pretty darn powerful. I mean, scarily powerful. Because what you're doing is you are literally cloning yourself. You are making a duplicate of who you are in this other person, so that they can be you in every circumstance, which is what I'm trying to accomplish. But there's a downside to it that you're giving them the keys to the castle. So you better trust them. All right? And that doesn't mean that your family's the best choice all the time. Usually, but it doesn't mean that that's always true. So it's a good question. Yes, ma'am.
Do these five only apply to the state of Florida?
Do these big five apply only to the state of Florida? I would say they have general applicability across all the states, with the one exception, is this trust issue. You see, in Florida, we have when it comes to Medicaid, we have a cap on how much income that you can have. But we can get around that cap by creating a trust called an income trust. So it's a very important ability to have. Michigan, for example, doesn't have an income cap. So the fact that that first thing, the ability to create a trust, isn't in your Michigan power of attorney and you're living in Michigan, not a big deal. The other four, I think, would be a big deal, even in Michigan. So, did I answer your question? Okay, very good. Yes, sir.
What qualities should we look for in an elder attorney when we go back?
Height, very important. Sorry. His question was, what qualities should we look for in an elder law attorney when we're looking for somebody to help us? Was that correct? Okay, and my answer was height. I'm 6'6", you see. But seriously, that's actually a very good question. When I first started practicing elder law 22 years ago, I was the third person in Pinellas County to specialize in this particular area. Now in Pinellas County, you have probably a choice of about 30. So there's been a Marion County, up by Ocala. Well, to give you an idea, it's kind of hard sometimes to figure out who to go to. I agree. Picking them out of the phone book's not so good. You might want to go to somebody in your support group, for example, who's had a good experience with a particular attorney and ask them if you are in a support group. Physicians, family, friends, whoever had a one-on-one type of experience. I will tell you from my perspective that I serve the entire state of Florida. So it doesn't have to be somebody right in your location necessary, as long as it's in the state of Florida. So Marion County, we do a lot in the villages, for example, specifically because we don't feel that there's anybody up there that's really serving the needs of this particular group. So it's a good question. Yep, I go to the villages. That's close enough. Yes, sir, in the back. Yes. Okay, question is this. It's like, well, you know, I have in-laws up, I have relatives up north and I have relatives here, and I go up north and I come down here. So, and that's a very common problem, obviously, in Florida. And the question is, well, who should be my power of attorney? So, and if I heard you correctly, you've solved that problem by having one person named up north and another person named down here. That's okay. It can get a little dicey if they don't agree necessarily, but if everybody's on the same page, it's like the two steering wheel problem, but it's okay to do. If you're evenly split between the two, I often recommend doing that. You want to make clear and sure, however, that the power of attorney document that you have does not revoke any other power of attorney documents. For example, the standard language in my power of attorney says that it revokes any prior powers of attorney because I want a clean slate. I don't want anybody else floating around out there that has a power other than the guy that I just nominated. So be careful, though, when you're naming two like that in two different states that you don't have that kind of language that might nullify the other person's authority, just as an FYI. Not anything wrong with it, not necessarily necessary. I don't recommend doing it that way, but there's not anything wrong with doing it that way. Okay? Anybody else on this issue? Yes, ma'am.
Does Florida take another state's power of attorney?
Does Florida take another state's power of attorney? A very good question. The answer is yes, with a qualification. The other state's power of attorney may not be good enough. It may be valid, do you follow me? Functional, but it may not, for example, have one of these big five. And if I can reverse the Michigan issue, had a lady ask me once, well, you know, I just moved down here 3 months before I moved down from Michigan. I got all my documents redone. Do I need to redo them? Do I need a new power of attorney for Florida? And my answer to her was yes. Well, isn't it good in Florida? Well, it's valid, but it's not any good because big five. They didn't, you know, Michigan, you don't need to do a trust to get eligible for public benefits. In Florida, you do. It's not, Michigan's power of attorney is not going to have that authority to create a trust because they don't need to in Michigan. So the answer to your question ultimately is it may be valid here in Florida, but my recommendation is if you're spending time in Florida, that you have a Florida power of attorney with these big five things in it. Okay? Better safe than sorry on that particular issue. All right. Yes, ma'am, over here. The question is do you need a Florida power of attorney if you don't own a home in Florida? And my answer to that question is you still need a Florida power of attorney. Whether or not you own a home in Florida is not relevant. Yeah, even if you have children on your title, even if you have joint bank accounts with your kids, all of those are ways to manage the problem of being incapacitated, but they don't go far enough or wide enough to cover everything that needs to be done. So I will go out on a limb here and say that the single most important legal document that you can have in your possession is a good quality, durable power of attorney. Okay? And in the context of Parkinson's disease, fundamental, absolute, without question, probably one of the single most important legal document that you can have, because of your propensity with this disease process of cognitive issues later down the line. Okay? One more question on this, and I want to switch to, I'll get you afterwards, but yes, you, sir.
For a period of time that a power of attorney is good for, in other words, you have a renewal, change every now and then, what do you have a specific rule, for example, with your clients, if the law changes, you contact all your clients and present those before? Can
I just say that you guys are asking really good questions. That's an excellent question. The question is this: is there a time period that a power of attorney is no longer effective? Is that good enough? And in other words, is 3, 5, 10, 15 years, is there a legal time period that thing stops being effective? And the answer, again, is another qualified answer, is there is no time period under the law where your document stops becoming valid or legal. However, I have a rule of thumb in my office that any document older than 5 years should be redone, not any, but the power of attorney document, excuse me, that particular document should be redone if it's older than 5 years. And the reason being behind this is that power of attorneys are like loaves of bread. Okay, and I'm not talking Wonder Bread, okay, that will be fresh forever, okay? These are like your normal kind of regular Publix bread, all right? If you leave it on the counter with the twist tie off, that bread's going to go stale eventually over time. Now, at what point in time does it become too stale that you don't want to eat it? I don't know. It all depends on your threshold, right? But at some point, it's not going to be any good. Powers of attorney are like that too. They're kind of getting stale over time. And when you show up at the bank with a 10-year-old power of attorney, they're going to be much less happy to see that document, okay? They're going to be disinclined. In other words, they're not going to want to use that document. So they want to see a fresher document, one that, that's hot out of the oven, that still has you with where in time you appointed that person. Not some person that you appointed 10 or 15 years ago to be you, somebody closer and proximate in time to today. There is no rule on it per se. It's just kind of this moving target. I've picked 5 years as the due date for a power of attorney. There are also, as you mentioned, changes in the law. Well, these changes in the law do not invalidate your power of attorney. Recently, on October 1st, 2011, we had the largest change in the power of attorney statute that I've seen in the last 22 years. We had some significant changes in 2000, we had some significant changes in 95, but they rewrote, in essence, the power of attorney statute. On your little sheet, on the back, I like numbers, big 5, and this is the super 7. These are the new 7 things after October 1st that you have to specifically initial in order to empower your power of attorney, empower your backup person to be able to do. If those 7 things are not initialed, they can't do them. And the reason why this is such an important point to make is that many of you guys might get the Susie Orman kit, for example. Best intentions, good document, not anymore. You might go out onto the internet and do a search in Google for durable power of attorney and find a form, print that thing out, put it in your word processor, and kind of DIY your own POA, which means do-it-yourself power of attorney. Don't do that. Because of the change in the statute, those forms that you're pulling out of off the internet or out of these other systems are not up to date to what Florida's law now requires. These super 7 things that you see on your orange sheet have to be initialed. If they are not initialed under Florida law, that power has not been granted to that person. So even though it says it in the document, if it's not initialed by you, it doesn't function for them to be able to do that. Do you understand what I just said? So it's these Super 7, I'm not going to go over them, you can read them yourself, have to be initialed on any power of attorney done after October 1st, 2011. So a very good question. Okay, yes, one more, and then I want to switch to Medicaid. I want to keep you guys on time here. The question is it true that the acceptance of a power of attorney is at the discretion of the receiver? And that's actually, again, a very good question and very sophisticated. The answer to that ultimately is no for documents done after 2001. 2001, there was a statute change that allowed you, it gave you, metaphorically, a stick. Now, what do you use that stick for? To beat over the head of the bank. Why do you have to beat it over the head of the bank? Because they got this power of attorney sitting in front of them that they're saying, nope, not going to honor it. Too old, don't feel like it, it's written, handwritten, it doesn't do this, doesn't do that, not going to honor it. Well, with this particular stick, it's an affidavit basically that says that the power of attorney is still in force and effect. With this stick after 2001, they have to honor it or pay the damages for their failure to honor it. And in my world where I've come up against this is in the context of Medicaid, for example, the bank or the broker saying, no, we're not going to, Merrill Lynch, for example, not going to let go of that money and let you take it out and move it. We're not going to honor the son's power of attorney. Why not? It's not on our form. Very common answer. And if you don't know any better, okay, right? You just kind of, because it's easier for them to say no than it is for them to accept it and suffer the other consequences of accepting one that's not valid. But what happens in that circumstance is you come to my office and you say, well, Sean, they're not honoring the power of attorney. And I write them this nice little letter that says, please find and close an affidavit that the power of attorney is still in force and effect pursuant to Florida statute, section 709, section 768. And by the way, your failure to honor this power of attorney will subject you to damages for my client's nursing home charges because you're not allowing us to have access so we can move them and qualify them for Medicaid, and that's at about $8,000 a month. As soon as I say that they're subject to $8,000 a month bill, they usually switch the gears and honor the power of attorney. You with me? So it's a very good question. The answer is for any power of attorney after 2001, if you have an affidavit saying the right little magic words and get that in front of them and maybe mention the whole damages issue, they usually change their mind. Okay? But it's a very common problem that they say no. I'm not going to honor it. It just boils my blood because they shouldn't, but it's easier for them to say no because you don't know any better. Okay? All right, let's switch gears. I'll be available afterwards to answer some of your questions on these specific things, but how long, Miss iPad, do I have? 5 minutes? 4 minutes. Okay? She has an iPad back in the room, and she holds it up. Get off the stage! No, just kidding. Yes, sir.
We're going to have questions for the
Excellent.
panel afterwards.
Okay.
So I would keep the questions.
Yeah, no problem. I like bringing questions in because they have a tendency to answer, bring my presentation onto what you guys want to hear. But I also want to talk a little bit about Medicaid now. Most of you, if you've heard the word Medicaid, have thought that it is a program for the poor. Yes or no? Okay. I understand that. Because when Medicaid was first created in 1968, it was part of our healthcare system that was designed to provide healthcare for the poor in this country. This inequality that I mentioned earlier, however, was created because when they provided care for chronic diseases such as Alzheimer's and such as Parkinson's disease, they stuffed that care over under Medicaid for whatever reason and didn't cover it under Medicare. So now we find ourselves today in 2012 in a situation where we're running into more and more to this chronic disease problems. Parkinson's would be one of them, and where we're relying on the nursing home more and more to provide care for our loved ones because we can't do it anymore as a caregiver. The problem with that is it costs you $8,000 a month. So the thing that I am most proud of in my practice is the ability to provide a solution to that problem, which is how to add $8,000 more a month to your cash flow so you can pay for the cost of care in the nursing home. Do you understand that? Without Medicaid, without the ability to access Medicaid, you're on the hook for an $8,000 a month bill. And if you are on the hook for an $8,000 a month bill for very long, again, you hit zero. In order to be eligible for this particular program, you have to meet certain eligibility requirements. Those requirements primarily are broken down into two financial, I call them tests. One is an income test, and the other is an asset test. How much assets you have, and how much income you have. In other words, the way I like to refer to it, Florida looks at what you get and what you've got to determine whether or not you're eligible for Medicaid. What you get is your income, what you've got are your assets. In Florida, they establish a line or a limit that you have to be below in order to be eligible for Medicaid from an income perspective. That limit in Florida right now is $2,094 of gross income per month. And that's only for the person applying for Medicaid benefits, not for a family or the group or the husband and wife together. It is for just the applicant. Their income must be below $2,094 of gross income per month. If it's above that, initially they are disqualified from Medicaid benefits. And I say initially because there is a workaround, a federal workaround, to solve this problem to get below this limit called an income trust. By implementing this income trust, you can fix this problem, get around having too much income, and now qualify under that one requirement. But you also have to qualify under the other one. And the other requirement is an asset requirement. Just like they look at how much income you have, they also look at how much assets you have. So I want to leave you today with probably the most important point regarding Medicaid. And this is something that's a little hard to believe. But the amount of assets that they allow you to have, I call it the target amount, does not matter. Okay? So when I tell you that they have, well, how much time do I have?
No.
Okay. Let me explain to you by telling you a story about my son. My son's 13 years old in May. This Christmas, he asked to have a dartboard as one of his gifts. And not one of those plastic dartboards, one of those real, like pub dartboards with the metal tips and, the whole, from England and all that kind of stuff. He wanted to learn how to play darts. And I was like, against my better judgment, you know why, right? Against my better judgment, I said, okay. And sure enough, on Christmas Day, under the tree, there was a dartboard. So he unwraps the present, pulls the dartboard out, and what does he want to do with it first thing? Play darts, right? Absolutely. So we hang this thing up on the wall, and I'm like, oh, my wall. Right? Hang this thing up on my wall, and I go to my son, I go, hey man, listen, I'm going to teach you how to play a couple different games, but the first game that we're going to learn is a game that's called accuracy. Do you understand? Accuracy. Why? My wall. Okay? So I get this dartboard, I hang it up on the wall, and I say accuracy. Now the fundamental rules of accuracy are very, very simple. Don't hit my wall. Make sure you hit the dartboard. And you win if you get a bullseye. Everybody with me so far? Okay. So sure enough, he gets it. He's a smart kid, no problem. He says, can I go first? I go, yeah, sure. And I hand him the darts. And it's about this point in time that I find out that this kid is the best dart player on the planet. Do you know why? Because he gets a bullseye every single time. Every time. It's pretty impressive, isn't it? Amazing. It blew me away, including the first time that he ever tries. So I give him the darts, and he goes, bullseye, right, Dad? And I'm like, yeah. And go ahead, man, go ahead. So he's like, all right. Looks at me, looks at the dart, looks at the dartboard. Walks up to the dartboard. Bang! Sticks that thing right in the center, right in the bullseye. Looks over his shoulder at me, and he goes, hey, Dad, this isn't a very hard game. Okay, now why do I tell you that story? Well, after I picked myself off the floor, okay, smart, I don't know where he gets it from, but he beat me, and he beat me fair and square, because there was no rule that said that you couldn't walk up to the dartboard and stick it in there. He also created the perfect metaphor for what I do for my clients. That bullseye is the target, is the amount of assets that you're allowed to have in order to be eligible for Medicaid benefits. So I want to leave you with this, is the size of that target doesn't matter. Why not? The size of that target is $2,000. That's all you're allowed to have to be eligible as a single person for Medicaid benefits, $2,000. And whenever I say that, without telling the story, most people's reaction is, oh my goodness, that's not very much money. I got more money than that. I'm never going to be eligible for this program. But what did I tell you? The size of the target doesn't matter. Just like the size of the bullseye for my son has no relevance at all, does it? As to whether he gets a bullseye every time? Now somebody tell me why not? Why isn't the size important for him? Because why? Because he's standing right next to it. He's eliminated every variable. There's no way he's not going to get a bullseye every single time because he controls every variable. There's nothing left luck. He's removed all the variables and he's going to get a bullseye every time. And the size of that target, whether it's this big or whether it's that big, makes no difference to him. From my perspective and what I do for my clients is the size of that target, that $2,000 number, it's just a math problem. It doesn't matter at all regarding whether or not you can qualify for these benefits. Okay? Believe me on that. And let me thank you for letting me speak with you today, and I look forward to answering some questions later. Have a great day, guys.